You're listening to The Real Estate Way to Wealth and Freedom podcast, episode 17.
Welcome to The Real Estate Way to Wealth and Freedom podcast with Jacob Ayers, providing actionable content to help you along your journey to financial freedom through real estate investing. As the premier asset class, real estate has helped ordinary people just like you amass fortunes. The benefits of passive income from real estate investing will allow you to live a life you want. And now your host, entrepreneur, real estate investor, and apartment deal syndicator, Jacob Ayers.
Hi, and welcome to the Real Estate Way to Wealth and Freedom podcast. I'm your host, Jacob Ayers. Today we're going to be discussing asset protection with Garrett Sutton. Garrett is an attorney, best-selling author, and one of Robert Kiyosaki's Rich Dad advisors. A clear and engaging writer, Garrett demystifies legal topics and presents them in a very understandable and accessible manner. Garrett has over 30 years' experience in assisting individuals and businesses to limit their liability, protect their assets, implement advantageous corporate structures, and advance their financial goals. Garrett is the author of, okay, buckle up because this is a long list. Start Your Own Corporation, Writing Winning Business Plans, Buying and Selling a Business, Loopholes of Real Estate, Run Your Own Corporation, and the ABCs of Getting Out of Debt in the Rich Dad Advisor series. Garrett is also the author of How to Use Limited Liability Companies and Limited Partnerships, along with Toxic Client, Knowing and Avoiding Problem Customers, and Finance Your Own Business, which he co-authored with Jerry Detweiler. Garrett is the owner and operator of corporatedirectcom, which since 1988 has provided affordable asset protection and corporate formation services, as well as resources for entrepreneurs and real estate investors. Robert Kiyosaki, the best-selling author of Rich Dad, Poor Dad, calls Garrett and Corporate Direct the premier source for asset protection strategies. Garrett attended Colorado College and the University of California at Berkeley, where he received a BS in Business Administration in 1975. He graduated with a JD in 1978 from Hastings Law, the University of California's law school in San Francisco. He has appeared in the Wall Street Journal, the New York Times, and other publications. Garrett enjoys speaking on asset protection strategies and is a frequent lecturer for business groups and the Rich Dad Advisors educational series. Garrett serves on the boards of the American Baseball Foundation, located in Birmingham, Alabama, and the Reno, Nevada-based Sierra Kids Foundation and Nevada Museum of Art. Today I welcome on the show Garrett Sutton. Garrett, thanks for joining us.
It's my pleasure, Jacob. Thanks for having me.
Absolutely. So Garrett, today we're talking asset protection for real estate assets. Can you tell us a little bit about your background and your experience?
Sure. I went to the University of California, and then Hastings Law School in San Francisco. And they don't teach asset protection in law school, so you kind of have to learn it yourself. And I practiced law for a number of years in Washington, D.C. and San Francisco. And, I got tired of the traffic and congestion, so I moved up to Reno. I like Lake Tahoe and skiing, and Nevada is a great place to set up an entity. So when I moved to Nevada, I started forming corporations for people, and then we learned about Wyoming and other good states. And so I just kind of grew towards asset protection. I like helping people start businesses and protect their real estate and other assets. So asset protection for me is really rewarding. I get to talk to people from all over the country, make suggestions on how best to protect your assets. Because as you grow your wealth, Jacob, as you buy more real estate, you need to protect yourself along the way. The government doesn't do it for you. You have to take the affirmative steps to protect yourself. So that's what I've made a career out of, and it's really enjoyable for me.
Yeah, that's great. So when you're talking about protecting assets, how exactly does one go about protecting their asset?
Well, it's important to know that if you hold title to real estate in your individual name or with a partner, your name is on title, you are personally responsible for everything that happens on that property, even if it's vacant land. So by holding title in your individual name, you're just taking on a great deal of risk. Now, you're going to have insurance, of course, But we know that insurance companies don't cover every claim. They have an economic incentive to not
Right.
cover every claim. As well, sometimes a claim can be so bad that it exceeds the level of insurance. You could have a $1 million policy of insurance, but a $2 million claim comes along, and you're personally responsible for that second $1 million. So do you want the title to be in your name where all your personal assets, the equity in your house, your bank account, all your other assets are responsible for that $1 million claim? Or do you want to have a good entity like an LLC that is responsible for the claim? And if the LLC doesn't have any more assets than the property, they're not going to collect from you personally. So that's why we like to have real estate held by a good entity, such as an LLC, in some cases an LP, a limited partnership, and thus protect our clients' assets and allow them to grow and collect even more assets.
Okay, so this business or this asset protection comes in the form of a business entity.
Correct.
Okay. So,
Correct.
Garrett, it seems that people often don't understand the reasons why they feel they must set up a business entity, whether that be an LLC, S Corp, etc. Could you start by explaining why a person may need to set up a business entity?
Well, sure. Well, one of the main reasons is I just mentioned, if you don't have title to the real estate in a business entity, then title is going to be in your name individually. And in that case, you're personally responsible. The tenant that falls on the property is going to sue the owner. If that's you personally, you're personally responsible for their injuries. So we want to set up an LLC. We certainly want to have insurance. Insurance is the first line of defense, but these entities are the second line of defense. And it's important to know, Jacob, that if a tenant sues an LLC with 10 properties in it, if that LLC is entitled to 10 properties, the tenant could get the equity in all 10 properties. They get to get what's inside the LLC. So maybe we don't want to put 10 properties into one LLC. Maybe it's one or two, at the maximum 3. Because if you have a target-rich LLC, the tenant suing can get the equity inside that LLC. If it's 10 properties, they could collect on 10 properties. So we want to have fewer than 10 assets in one LLC, maybe 1, 2, or 3 properties, and leave it at that. And then the next step is when you buy that 4th property, is we set up a brand new LLC for the protection. Now, in terms of taxation, the LLC is a flow-through entity, meaning there's no tax at the LLC level. Everything flows through to you. So you're not going to notice a huge tax difference by setting up these LLCs. The main difference is asset protection. That's why you're setting up these LLCs.
Okay, great. So really it comes down to your risk profile on, how many properties you may want to put in a certain LLC or along those lines. So could you give an example of what an asset protection strategy would look like for someone who's just beginning to invest in real estate? Perhaps they've just purchased their first property or looking to purchase their first property. Maybe they don't have a ton of assets to quote unquote protect. What would a typical asset protection strategy look like for that type of person? Okay.
Well, let's talk first about the issue. They don't have a lot of assets to protect. If they get sued personally, someone who has a judgment against them can renew the judgment every 7 years. So it's not what you have to protect now. It's what you're going to have into the future. So the fact that you don't have any assets now doesn't mean you shouldn't have asset protection, because people have a way to go after you for years and years and years. So we want to set the entities up now. Now, if your client is going to buy a property in Texas, for example, and they're just going to have one property, I would set up a Texas LLC. We typically set up an LLC in the state where the property is located. You own real estate in the state of Texas, in our example. Texas law is going to apply. It makes sense to have a Texas LLC. Now, I have plenty of clients, and you probably have plenty of listeners, Jacob, who would have a property in Texas and then perhaps another one in, say, Utah. So when we get that second property, we would not put it in the Texas LLC. We would set up a new Utah LLC to hold that property. The reason we wouldn't use Texas is twofold. One, we don't want to put too many assets per LLC, but also if we qualify Texas into Utah, right? We take the Texas entity and want to do business in Utah.
Right.
The price is the same whether you have two LLCs or one. So you have better protection with two. Now, that strategy, I just want to add one more element to the strategy. The Texas LLC and the Utah LLC would be owned by the same Wyoming LLC. And Wyoming gives us charging order protection. That means all someone can get is a lien on distributions. They can't force a sale of the Texas or Utah properties. They have to fight through the Wyoming LLC. The Wyoming LLC gives you the best asset protection in the country, and it's very affordable. The price for a Wyoming LLC every year is only $50 per year, and they don't list your name on the Secretary of State's website, so you have privacy. So the strategy, if you looked at someone holding balloons, right, we'd have a balloon at the top for Texas, another balloon at the top for Utah. The properties are in LLCs there. The two balloons are owned by the Wyoming LLC. If you get sued in a car wreck, Jacob, it has nothing to do with the real estate.
Mm-hmm.
Someone sues you in a car wreck, they want to get at the Texas and Utah property. They have to fight through Wyoming. Wyoming's law says the exclusive remedy is the charging order, which means the person who is in the car wreck has to wait for distributions to be made from Wyoming. Well, maybe there aren't any distributions. Maybe the Texas and Utah LLCs hold on to that money and don't distribute it to Wyoming. Then there's nothing for Wyoming to distribute to the person with the charging order. The key to all this, Jacob, is attorneys are on contingency fees. When they sue in a car wreck, they get a percentage of what's collected. So say they're going to get 35%. Attorneys know how to get at the insurance money. And I always recommend that people have insurance, right? And even an umbrella policy of insurance. You always want insurance.
Absolutely.
So you have insurance that someone could reach. The attorneys know how to get it. But then if your other assets are held in LLCs, especially Wyoming or Nevada LLCs, it's hard for the attorneys to get at that stream of income. There's a lot more work involved. And attorneys, being rational economic animals, are going to say, do I want to have to hire an attorney in Wyoming to pursue this claim and wait around to get paid, or do I want to go to the next case that has insurance monies that I can get 35% of? So that's why we like to structure it this way. We want our clients to have insurance, an umbrella policy of insurance, and then to have their assets in LLCs, which are difficult for attorneys to reach. So that's kind of an overview of the whole strategy. I go through it in the book, Loopholes of Real Estate. So it's all in that book. But that's kind of the structure. And when we get on the call with people, we do 15-minute consults, we'll explain that to them. But your listeners, Jacob, have what our structure, which is a LLC in the state where the property is located, and a number of LLCs being owned by one Wyoming LLC.
Okay, so that sounds like a fairly simple structure. Sometimes I hear of people with strategies where they're, series LLCs upon series LLCs and, all of these holding entities, and it just gets to be almost cumbersome. And then you've got the opposite end of the spectrum where some people have multiple properties and don't have any asset protection. So it sounds like your remedy is right there in the middle and on found reasons.
Yeah, I would be cautious of the people who, are selling more entities than you need. You don't need levels and levels and levels of LLCs. unless you want to pay someone who is there to take your money for creating levels and levels of LLCs. You need to engage in critical thinking. You have to ask, is this guy, charging me all this money for something I really need? You do need the asset protection. So we don't want to be on the far end of the scale where we don't have any LLCs, but you don't need 17 LLCs to do this right. As we discussed, you need an LLC in the state where the property is located, and I always recommend an LLC in Wyoming or Nevada to hold those other LLCs. So we make it efficient and affordable, and you don't need to have all these extraneous entities around.
Okay. So many people, when they're getting started, or they may be delaying started because they don't have this business entity set up. Is this really a crucial first step in your opinion? Or if people who've gotten started, maybe purchased a few properties without any asset protection, are they in a bind? Is it fixable?
Yeah, it is fixable. So if you have a property, say you buy your first property, and I see this a lot, Jacob, it does happen. You buy your first property, it's a single family home, and you're renting it out, and it's in your individual name. As we discussed, you are personally responsible for whatever happens on that property. You do have the ability, though, to transfer title from your name to the name of the LLC. And you haven't sold the property. There's no taxable event here. You're just transferring how title is held from your name to your own LLC. So there's no transfer tax in most states. Pennsylvania, you have to be careful of there, even though it's from you to you, there's a 2% transfer tax, which is kind of onerous. So you want to take title in the name of the LLC right off the bat. But let's say you bought that single family home, that duplex, it's in your individual name. We just do a grant deed or a warranty deed from you to the LLC. You don't want to do a quitclaim deed because the title insurance doesn't follow. But it's very easy. You just and we have a service that we recommend that'll do the deed work, and you just transfer it from you to you. So it's not too late. It's not like you're by taking title in your individual name, you have to hold it that way for the next 200 years. You could change it tomorrow. The other thing, you raised the question of if someone's getting started and they're going to buy a piece of real estate in the next 6 months. It takes us about 2 weeks to get an LLC formed. So, you could set it up ahead of time if you're going to buy real estate, but sometimes you don't know what state you're going to buy in. And so I'd rather have you wait and set up the entity when you're sure that you're going to buy that property in Missouri, right? We set up a Missouri LLC at that time, instead of setting up an entity in a state where the property is not located.
Right. Okay. So ideally, take title in the entity when you initially purchase the property.
Correct. Now, some banks won't let you do that.
Right.
They want title to be in your name, but most of them understand that people want to have the asset protection of an LLC. So you can actually tell the title company, put title in my name, and then a day later transfer it into the LLC. It can be done that way. Most banks understand this. If they don't, you use the magic words continuity of obligation. And what that means is, and this is what the FHA allows, the continuity of obligation means that the bank still has your personal guarantee, right, on the note. Moving it into an LLC doesn't mean that you're no longer responsible for the note.
Right.
The bank still has a first deed of trust on the property. The fact that it goes from your name into the LLC doesn't remove the first deed of trust. So there's a continuity of obligation. You as the individual are still responsible for paying off that note. The bank has security in the first deed of trust. That still exists. So if you run into if you deal with a bank that is having a problem with this, you just say, look, there's a continuity of obligation there. I'm still responsible for the note. And more banks, this was more of an issue, Jacob, 10, 15 years ago. More and more banks are realizing that people need to have assets in LLCs and will allow it to be done. they have this funny idea that they need to take title that you need to take title in your individual name and then transfer it to the LLC. But so be it. Unless you're in Pennsylvania, it's not that big of an issue.
Right. Yeah. That's kind of been a big mental roadblock for many people, is triggering that due on sale clause of their mortgage. Right. And from anyone I've ever,
you haven't sold the property.
Right.
Right. The due on sale clause is when you sell the property. You've just transferred it from your name to your LLC. There's no sale there at all.
Good point.
And so they use the due on sale clause to kind of confuse people, but there's been no sale. It's not a taxable event. You've transferred title from your name to an LLC that you hold. It's one and the same.
Right. So you've never, in your experience, seen that due on sale clause triggered when transferring title from your name to an entity?
Well, some of these bank officers will huff and puff and say that the due on sale clause is triggered, but then you explain to them the situation. Legally, it has not been triggered. Unless they add special language where they don't allow a transfer. I've seen that once.
Okay.
But otherwise, and why wouldn't they allow a transfer? Here's the thing. You're going to be paying the mortgage every month, right? The bank is going to get a check for the mortgage. Whether it comes from your checking account or the LLC checking account, what's the difference? They're not going to see a discontinuation of payments. You're going to keep paying it month after month. So, the bank is not going to call the note when it's performing. And that's why when it comes to this transfer of title, I always ask my clients, is it better to ask for permission or forgiveness, right?
I like that.
Just tell the bank that, that you thought this was fine. I didn't ask for permission, but if it's wrong, I'm asking for forgiveness. And then there's strategies we can use. We talk about in Loopholes of Real Estate, how to, go to plan B if the bank is insistent. But really, Jacob, most banks now are not that difficult to deal with on the LLC issue.
Right. Okay. Well, good to hear. Garrett, are there differences in asset protection for different property types and sizes? Say if a person is investing in an apartment deal with other investors versus owning a single family home.
Well, if you're owning a single family home, that would be your own LLC. If you're going to be buying a apartment building with other people, there's a couple things. One would be that you could have it in one LLC, which everybody owns. For example, 5 guys own 20% each of. Right. You could use one LLC for that. Now, if you wanted to do a 1031 exchange, you'd have to use that same LLC for the next property, okay? Because the 1031 exchange, where we get the tax-free treatment, says that the owner of the old property has to be the same owner of the new property. If you have 5 guys that are putting money into the building, and I know this is a little complicated, but if you have 5 guys that want to go their own way after a 1031, like after we do the 1031 on the apartment building, you want to buy your own fourplex. I want to buy my own industrial building. If we used one LLC in that situation, we'd all have to buy the same piece of property. We'd only get one choice. However, if we have title to the apartment building in tenants in common, where each of the 5 investors has their own LLC on title as tenants in common, then each person can go their own way. The 20% owner would get 20% of the proceeds, and they could use their own LLC to buy the next property. So if we're looking at a 1031 possibility, we would use separate entities for each tenant in common. In the single family home example where you own 100%, you only need one entity in that case. And I know some of this is kind of complicated, but we do talk about it, and you can call the office, and we do counsel people on these issues. But there are a lot of strategies out there for 1031 exchanges that you should know at the start. If you think there's a possibility for a 1031 tax-free exchange in the future, whereby you hold a property for a year and then you sell it and transfer without taxes to a new property, then the tenants in common way is the best way to go.
Okay, yeah, that's really good to know. I know a lot of our listeners are involved in multifamily properties and deals, and so knowing the difference between those types of assets and single family is really important.
Good.
Garrett, why should a person hire an asset protection lawyer such as yourself rather than try to set up and maintain their own entity? What value?
The two words that come to mind are horror stories.
Okay.
The people that try and do it themselves with these online services,
Mm-hmm.
some of them are fine, but they come back to us with these horror stories. An online service doesn't know that you should never use a C corporation to hold real estate. And so they'll let you set up a C corp for real estate. That is probably the biggest mistake you can make. On a $400,000 gain, you'll pay $90,000 more in taxes by holding real estate in a C corp than you will if it's in an LLC. So that's one example. A lot of the LLCs that are set up by some of these online providers, they just don't have the right documentation. It's one thing to register the entity with the state, and a lot of people, they pay $99 for that and think they're done. You're only about 30% of the way there. You need an operating agreement. You need minutes. You have to issue the membership certificates. If the IRS comes calling on an audit and you haven't issued the membership certificates for the LLC, that is a bad thing. And so a lot of people will come back to us and say, yeah, I made a mistake. I used this cheap service, and we're not, we're not very expensive to begin with, but they used the really cheap service. They didn't get the full complement of paperwork necessary to prove that they're a properly formed LLC. And so we'll clean it up for them. We have a cleanup service where we'll put the pieces that they need together so that they can, if ever called upon, prove that they're a legitimate LLC. And this allows them to avoid piercing the corporate veil where somebody says, this LLC I was doing business with didn't follow the corporate formalities. They didn't have an operating agreement. They didn't issue the stock or the membership interests. I want to pierce through the LLC veil and go after them personally. This happens a lot. And the cases are successful 50% of the time. So it means a lot of people are not doing these LLC setups properly. So you just want to be careful with some of these LLC online services because this is important stuff. It's not hard to do. It's not time consuming or expensive to do, but failing to do it can be really dramatic. It can be really a bad thing for you to be held personally responsible for these claims. So I always recommend that people do it right at the start. If you haven't done it right at the start, you can call our office and we have a cleanup service where we'll get everything up to Hoyle for you.
Okay, great. So you really have to make sure you're going to cross your T's, dot your I's if you're going to try to do this yourself. And if not, you open yourself up to potential litigation by allowing someone to pierce your corporate veil, essentially meaning your entity is not of use.
Right. The court says, look, the state charters LLCs and corporations for limited liability, but you have these ongoing formalities to prove that you're operating as a properly functioning LLC or corporation. And if you go into court and you don't have everything in order, the court could easily say, you haven't followed the formalities, you haven't followed state law, and as a result, you're personally responsible. And again, it happens 50% of the time these cases are brought.
Right. Okay. Circling back to a topic we discussed just a minute ago, Garrett, we kind of jumped right into why you should have an LLC. Is there ever any scenario where you should hold real estate in anything but an LLC?
The limited partnership offers the charging order protection. And the advantage of the limited partnership is the general partners control all activities in the LP. With as little as 2% ownership of the LP, the general partners can control everything. Now, the general partners, if they're individuals, are personally responsible for the activities of the LP. So we have to set up a second entity. You set up the limited partnership like you do an LLC, but the general partners, because they're personally responsible, we have to set up a second entity, a corporation or an LLC, to be the general partner. So the downside is you have to set up two entities instead of one with an LLC. The plus side is mom and dad, with as little as 2% ownership, they've gifted to the kids over the years, gotten it out of their estates, but with as little as 2% ownership, they can control everything within that LP. And so they can hold on to control until the kids are ready to assume control. Or, maybe mom and dad need to use this real estate for their health insurance. They could have the LP pay the general partner for managing the properties. The money there could pay mom and dad's expenses, real estate, health insurance, home office, cars, all the expenses for mom and dad can be paid through the general partnership. So that's a good way to go in certain family planning circumstances. But as to your other question, would you ever hold title in your individual name? I wouldn't. We live in just a very litigious society. People are looking for people to sue nowadays. And so I would always hold title in the name of an LLC or an LP. A lot of people think if they hold title in the name of their family trust, their living trust, that provides asset protection. And that is not the case. A lot of promoters sell these living trusts as an asset protection device, and they're not. They do avoid probate. It means you don't have to go to court to settle the estate, but the living trust provides no asset protection. So if you take title to a fourplex in your living trust, the living trust, a tenant sues over the fourplex, the tenant can get everything that's in your living trust, all your assets for retirement. So that's the last thing we want to do. So we always want to have the LLC to be on title, and then in turn, it can be owned by the living trust. The LLC gives you the asset protection. The living trust gives you the probate avoidance. They work together, but separately they don't. Separately they're not that helpful. They need to work together.
Okay, great. And I know you explore a lot of different opportunities and scenarios in your book, Loopholes of Real Estate. So if anybody's looking to understand a bit more about how these different entities can be set up, picking up that book would certainly be of benefit.
Well, thank you. Yeah, it's been a popular book, and we go into strategies that you're not going to see in other real estate books. People, I love reading the reviews on Amazon because it's fun to see how the book has been helping people invest in real estate and understanding the strategies on how to protect yourself.
I think one of the best qualities of the book, Garrett, is you have a very clear and easy way of making it understandable to just your layman. So very, very good. I highly recommend it.
Well, I try to avoid legalese. You want to write in English, not legalese.
Right. So, Garrett, I initially asked you why a person should hire an asset protection lawyer like yourself. And another thing I think you bring value is you often work hand in hand with your clients' CPAs. Is that correct?
Absolutely. Too often, Jacob, the CPA will say that's a lawyer question, call the lawyer. And then the lawyer says that's a CPA question, ask the CPA. And you're playing ping pong for 6 months. I think it's best where the CPA, the attorney, and the client get on a call. You don't have to travel. We do it over the phone. Get on a call together and sort everything out.
Right. Okay.
That's what we do. And our new book, the new Rich Dad Advisor book, is called More Important Than Money. It's being released here soon. And it's about building a team. That is so important when you're starting to invest in real estate, investing in businesses and all, to have that team by your side, the attorney, the CPA, the bookkeeper, the banker, the insurance agent. You need those people on your team. You need to develop relationships with them. You need to make sure you're working with someone that you like and trust. If someone won't return your calls for months on end, you need a new person on your team. It's your decision. Too many people think that they have to go with the first person that they're referred to or who their brother-in-law said to use. It's really your personal decision on who's on your team. And, if someone's not performing, get a new team member.
Right. Simple enough. All right, Garrett, as we're wrapping things up here, do you have anything else that you'd like to share with the audience?
Just that I think the education is important. The Rich Dad Advisors have books and audio tapes for people to gain information. But at some point, you just got to get out there and do it. Realize that you're going to make mistakes. I certainly did in my first property. And those mistakes aren't going to kill you. You're going to learn from them. And you just need to get out there and do it. And, you'll look back 10, 15 years from now and say to yourself, thank God I did it. Thank God I started investing in real estate, because this has been the right thing for me and my family.
Right. All right, Garrett, where can our audience contact you or learn more about your services?
Yeah, the best way, Jacob, is to go to corporatedirectcom. And we have all sorts of articles and information there. You can sign up for a newsletter. We keep you informed on what's happening with asset protection around the country, because it's a dynamic area of law. Things do change. We have informative articles there. And you can also call the office and get a free 15-minute consult with an incorporating specialist. So that number is 800-600-1760. 800-600-1760, or Corporate Direct. And, we don't, the fee for setting up an LLC is $695 plus the state filing fees, which vary from state to state. If you do a few of them, the price comes down. So we're not talking about $5,000 or $10,000 or $20,000 like certain people charge. We make this very affordable. We want to make sure that you're set up properly at the start and then protected on an annual basis. So we'll help you maintain your company, provide the resident agent services, provide the minutes that are needed. So that's our niche, Jacob, is just setting up these entities and making sure that they stay current so that our clients are protected.
Okay, great. Well, thank you very much, Garrett. We appreciate you coming on the show today.
Thank you, Jacob. It's been a pleasure.
All right, take care.
All right, thanks.
All right, that wraps up our episode today with Garrett Sutton. As you can tell, Garrett and his team at Corporate Direct had a ton of experience helping investors just like you protect their assets. You too can make Garrett and his team a part of your team. You can contact him at 1-800-600-1760 for a free 15-minute consult. If you're getting value out of this show, please let me know by leaving a rating and review in iTunes. Please subscribe to the show to be notified of new episodes. You can now find the show in iTunes, Google Play, Stitcher, Spreaker, and TuneIn Radio. As always, if you have any questions or comments or just want to drop me a line, feel free to do so. You can reach me at info@jacobayers.com or www.jacobayers.com. Till next week, signing off, I'm your host, Jacob Ayers.
You've been listening to the Real Estate Way to Wealth and Freedom podcast, providing you actionable content to build your real estate empire. Nothing on this show should be considered specific, personal, or professional advice. Please consult an appropriate tax, legal, real estate, financial, or business professional for personal advice. The opinions of guests are their own. Information is not guaranteed. All investment strategies have a potential for profit or loss. The host is operating on behalf of the Real Estate Way to Wealth and Freedom, LLC exclusively.